The difference between severance pay, UPMK, and UPH and their legal basis. The following are the differences between severance pay, long service award pay, UPMK, and replacement of rights, UPH, along with their legal basis. Severance pay, compensation that must be given to employees affected by termination of employment, PHK, as a form of protection for workers. The amount of severance pay is calculated based on the employee's length of service. Legal basis, Law Number 13 of 2003 concerning manpower, Article 156, Paragraph 2. Example: employees with a work period of 1 year to 2 years are entitled to 2 months' wages as severance pay. Long Service Award Pay, UPMK, an award given to employees based on their length of service at the company. UPMK is given to employees who have worked for at least 3 years. Legal basis, Law Number 13 of 2003 concerning manpower, Article 156, Paragraph 3. Example: employees with a work period of 3 years to 6 years are entitled to 2 months' wages as UPMK. Rights Replacement Money, UPH. Compensation given to employees to replace certain rights that have not been used during the work period, such as annual leave that has not been taken. Legal basis, Law Number 13 of 2003 concerning manpower, Article 156, Paragraph 4. Example: calculation of annual leave replacement money can be done using the formula 125 CAIV basic salary plus fixed allowance, remaining leave not taken. The 4 aspects that differentiate the 3 are: purpose, severance pay as compensation for termination of employment, UPMK as an award for length of service, and UPH as a replacement for rights that have not been used. Requirements: severance pay must be given upon termination of employment. UPMK is given if the minimum length of service is 3 years, and UPH is given based on rights that have not been used. Calculation: each has a different calculation formula. Legal basis: all 3 are regulated in Law Number 13 of 2003 concerning manpower. Contract law in Indonesia, void and its consequences based on Supreme Court decisions. Contract law in Indonesia, void and its consequences based on Supreme Court decisions. Contract law in Indonesia is regulated in the Civil Code, KUH Perdata. A valid contract must meet objective and subjective requirements. Here are some important aspects related to void contracts and their consequences based on Supreme Court decisions. Void contract. Objective requirements. A contract is void by law if it does not meet objective requirements, such as agreement of the parties, certain matters, and lawful causes. Subjective requirements. A contract is void by law if it does not meet subjective requirements, such as the capacity of the parties. Consequences of void contract. Return to condition before contract. If the contract is void, the parties must return to the condition before the contract was made. Compensation. If one party causes the contract to be void, the other party may request compensation. Supreme Court Decision, Supreme Court Decision Number 3335, KPDT 2003. An agreement is null and void if it does not meet the requirements of the parties' agreement. Supreme Court Decision Number 406, KPDT 2007. An agreement is null and void if the object or achievement is not certain. Legal implication: importance of agreement of the parties. Agreement of the parties is very important in making a valid agreement. Importance of clarity of object or achievement. Clarity of object or achievement is very important in making a valid agreement. By understanding the law of agreements in Indonesia and its consequences based on the Supreme Court's decision, the parties can make a valid and effective agreement and avoid potential disputes in the future. The legal basis for cross-border merger dispute resolution methods includes several approaches, including arbitration. Arbitration is a dispute resolution method that involves a neutral third party, namely an arbitrator, to decide the dispute. The advantages of arbitration include speed of process, confidentiality, flexibility, and final and binding decisions. The 1958 New York Convention is the basis for international recognition of arbitration decisions. Mediation. Mediation involves a neutral third party who helps the parties reach an agreement. Mediation offers full control over the process and results, low costs, and maintenance of good business relationships. International litigation. International litigation is the process of resolving disputes through the courts. Although more time-consuming and costly, International litigation can be an option when the dispute involves complex legal issues. Negotiation. Negotiation is the initial and simplest method of dispute resolution, where the parties try to resolve the dispute through direct discussion. In resolving cross-border merger disputes, it is important to consider several factors, such as forum selection, determining the forum that has the authority to adjudicate the dispute, such as a court or arbitration institution. Applicable law, determining the applicable law in dispute resolution, such as national law or international law. Legal consultation, consulting with a law firm experienced in international law to ensure effective and efficient dispute resolution. Some relevant legal sources in resolving cross-border merger disputes include Cord. 1958 New York Convention regulates the recognition and enforcement of international arbitration decisions. National law. The national laws of each country involved in the dispute may apply in dispute resolution. International treaties. International treaties can be the legal basis for resolving cross-border merger disputes. Can you mortgage a house without the permission of other heirs? What is the legal basis? Mortgaging a house without the permission of other heirs can have different legal consequences depending on several factors. Here are some relevant legal bases. Civil Code. Article 1151 states that anyone who has the right to an item can control and utilize it, provided they do not violate the rights of others. The Mortgage Law No. 4 of 1996, Article 1, Paragraph 1, defines a mortgage right as a guarantee over land and objects integral to it. Mortgaging a house without the permission of other heirs is often not allowed. If the house is a joint property or an undivided inheritance, the mortgage might be invalid if it violates other heirs' rights. Legal basis. Article 1088 of the Civil Code states every joint owner can manage joint property, but must not harm the rights of other joint owners. Legal consequences include a mortgage agreement being void and other heirs filing a lawsuit if their rights are violated. Recommendations include obtaining permission from all heirs, using their power of attorney if necessary, and involving a notary for security and legitimacy in the mortgage process. Always consult an experienced legal expert to navigate inheritance and property laws, which can vary case by case in Indonesia. PKWT compensation in Article 62 of the Manpower Law is an obligation for parties who terminate the employment relationship before the end of the period stipulated in the Fixed-Term Employment Agreement, PKWT. The following are details regarding PKWT compensation. Definition of compensation. Compensation is a cost that must be borne by the party terminating the employment relationship to the other party in the amount of the laborer's wages until the end of the work agreement period. Obligation to pay compensation. The party terminating the employment relationship, both the worker and the employer, is obliged to pay compensation to the other party if the employment relationship is terminated before the end of the PKWT period. Calculation of compensation. The amount of compensation is the amount of the laborer's wages until the end of the work agreement period. For example, if the worker has a salary of IDR 6,000 per month and his/her contract ends in 6 months, but the company terminates the contract early, then the company is obliged to pay compensation of IDR 36,000, 6 months, IDR 6,000. It should be noted that this compensation is different from the compensation money that employers are also required to pay to workers in cases of termination of employment before the end of the contract. Procedures for submitting and using a PT name are based on Indonesian law. Procedures for submitting and using PT names under Indonesian law. To submit and use a PT limited liability company name in Indonesia, follow these steps. Submitting a PT name. Eligibility. The name must meet specific requirements, including being written in Latin letters, not having been used by another company, and not conflicting with public order or morality. Application process. Submit an application to the Minister of Law and Human Rights through the online system for Legal Entity Administration, SABH, or in areas without electronic access via registered mail. Required documents. Although not explicitly stated, the application should include the proposed name and its compliance with regulations. Requirements for PT names. Written in Latin. The name must be written in Latin letters. Unique. The name should not have been used by another company or be too similar to an existing company's name. Not conflicting. The name should not conflict with public order or morality. No numbers or unformed letters. The name should not consist of numbers or unformed letters. No meaning as other entities. The name should not imply it's a different type of entity, e.g. PT, CV, Sejatera. Relevance to business. The name should reflect the company's purpose and activities. Using a PT name, format, the name should start with Limited Liability Company, or PT. Public companies. For public companies, the name should end with TBK after being listed on the stock exchange. Language. Companies owned by Indonesian citizens or entities must use Indonesian language names. Approval and rejection. Approval. The minister will approve or reject the name application within 3 working days. Validity. If approved, the name is valid for 60 days, during which the company must finalize its establishment. Responsibility. Applicant's responsibility. The applicant is responsible for ensuring the name complies with regulations and does not infringe on third-party rights. What are the duties and responsibilities of the company's audit committee? The audit committee plays a crucial role in ensuring the integrity and transparency of a company's financial reporting and internal controls. Here are some of the key duties and responsibilities of an audit committee. Oversight of financial reporting. Review financial statements. Ensure that financial statements are accurate, complete, and comply with relevant laws and regulations. Monitor accounting policies. Review and approve accounting policies and practices to ensure they are consistent with industry standards and regulatory requirements. Internal controls and risk management. Evaluate internal controls. Assess the effectiveness of internal controls and identify areas for improvement. Monitor risk management. Oversee the company's risk management processes and ensure that risks are properly identified, assessed, and mitigated. Minimum capital requirements for listing on the stock exchange. Business assistant. To be listed on the Indonesia Stock Exchange, IDX, companies must meet several minimum capital requirements that vary depending on the listing board chosen. Here are some minimum capital requirements that need to be met. Main board. Equity. Minimum IDR 100 billion. Number of shares released to the public. Minimum 300 million shares, or 20% of paid-up capital for equity less than IDR 500 billion. 15% for equity of IDR 500 billion, IDR 2 trillion, and 10% for equity of more than IDR 2 trillion. Development board. Equity. Minimum IDR 5 billion. Number of shares released to the public. Minimum 150 million shares, or 20% of paid-up capital for equity less than IDR 500 billion, 15% for equity of IDR 500 billion, IDR 2 trillion, and 10% for equity of more than IDR 2 trillion. Equity, minimum IDR 1 billion. Number of shares released to the public, minimum 150 million shares, or 15% of paid-up capital. In addition, the company must also meet several other requirements, such as QUAID, clear organizational structure, minimum profit, IDR 1 billion in the last year for the main board, while for the development board and acceleration board it may not have generated a profit but must have clear business prospects. Real assets, net assets that have been reduced by tax liabilities, at least IDR 100 billion for the main board and IDR 5 billion for the development board. Good financial statements, prepared in accordance with Financial Accounting Standards, SA, and have been audited by a public accountant. Number of shareholders, minimum 1,000 shareholders for the main board, 500 shareholders for the development board, and 300 shareholders for the acceleration board. Tips for buying Giric land safely based on Indonesian law. Buying Giric land in Indonesia can be a bit complex due to its unique characteristics and limited legal strength compared to certified land. Here are some tips to consider for a safe purchase. Understanding Giric land. Giric land is a type of land ownership document that originated from the colonial era, and while it's recognized locally, it doesn't hold the same legal weight as a certified land title, such as Hak Milik SHM or Hak Guna Bangunan SHGB. To ensure a secure purchase, it's crucial to understand the limitations and potential risks associated with Giric land. Should you change company data and articles of association in a merger? Indonesian law. Yes, in the process of company mergers in Indonesia, changes to company data and articles of association are often required. Here are some reasons and procedures that need to be considered. Changes to company data. Changes to company name. If the merging company wants to change its company name, then changes to the company data need to be made. Changes to organizational structure. Mergers can cause changes to the organizational structure, so changes to the company data need to be made to reflect the new structure. In Indonesia, cooperatives and foundations are both recognized forms of organizations, but they serve different purposes and are governed by different laws. Here's what you need to know. Establishing a foundation. A foundation, or yayasan in Indonesian, is a non-membership legal entity established to achieve specific social, religious, or humanitarian goals.